Good afternoon, everyone. My name is Iritiolu Abanjo. You're warmly welcome to another webinar organized by the Corporate and In-House Counsel Committee of the Chartered Institute of Arbitrators Nigeria branch. You are warmly welcome. Thank you for joining us from different locations, different parts of Nigeria and the world. We're happy to have you here today. On behalf of the Chartered Institute of Arbitrators, you're warmly welcome to this webinar. I will be your session coordinator. So before we dive in, we have just a few housekeeping rules. Please do not drop your personal details in the chat room. As long as you had registered with your Supreme Court number, we have noted your attendance at today's meeting and the approved point today will be allocated to you accordingly. Please, let's keep our phones muted and you can drop your questions at any time during the session. Okay, in addition, we will also have a poll sometime during this webinar, so feel free to give us your answers to help us understand and to have data on what we're really talking about today. The topic of today's webinar is mediation as a strategic tool for in-house counsel. Some people might be surprised. This is Chartered Institute of Arbitrators. Why are you talking about mediation? The Chartered Institute of Arbitrators strongly supports mediation as a vital tool for dispute resolution, and it is very complementary to arbitration. You can see them as maybe brothers or sisters. Yes. For this topic today, we have a very distinguished panelist. I'll be starting in no particular order. I'll be starting with Mr. Adeyemi Akinsoya. He has over 4 decades of experience spanning both domestic and international energy transactions, regulatory engagements, complex projects, stakeholder engagement, and stakeholder sensitive negotiation. He is the principal of Adeyemi Akinsoya Associates, and he sits on multiple respected panels. He's a co-founder and chief executive officer of the Dispute Solutions Hub, TDSH. Join me to warmly welcome him to today's webinar. We also have Mrs. Achere Cole. She's the CEO and director of the Lagos Multi-Door Courthouse. I've been admiring her for a very long time, let me confess. She has over 22 years experience in arbitration, mediation, restorative justice, and ADR system design. She has worked on several ADR and justice reform initiatives, including with the Judiciary of Kenya, World Bank, European Union, and others. She sits on several panels and boards. Yeah, thank you. I can see the claps. Thank you. Bring it coming. She's a fellow of the Chartered Institute of Arbitrators, a CEDR accredited mediator. She's a sought-after speaker and regularly presents at national and international forums. We're very pleased to have you with us today, Ma. And our last speaker is Mr. Godwin Omaka, SAM. He's a partner in dispute resolution practice group at Templars in Lagos, Nigeria. He has extensive experience in domestic and international arbitration in a wide range of disputes across different sectors. He is recognized by all major directories, including Legal 500, Chambers and Global, and IFLR 1000 as a leading arbitration practitioner in Nigeria. He's a fellow of the Chartered Institute of Arbitrators. He is a fellow of Institute of Construction Arbitrators, and he is the president of the Institute of Chartered Mediation and Conciliators of Nigeria. He sits on boards of domestic and international associations. Can we warmly welcome Mr. Godwin Omwaka? Also with us is our able moderator to take us through our conversations today, Mr. Samuel Ofosu Asamoah. I guess I didn't murder your name. He's one of us. He's a legal counsel and company secretary of Ghana Oil Palm Development Limited, one of the largest integrated oil palm value chain agribusiness in Ghana. He leads the legal and secretarial functions, supporting the board and its committee. His work spans corporate governance, complex land and community relations, major commercial contracts, litigation management, and compliance with Ghanaian law. He holds an LLM in corporate and commercial law at the University of Ghana. Thank you very much. He's an associate of Chartered Institute of Arbitrators and a member of the Ghana Bar Association. You are in for a very exciting conversation today, judging from all the conversations we've had before today. So let me hand over to Samuel to take us through today's webinar.
Thank you very much. Good afternoon, everyone in Nigeria. Good afternoon, everyone joining us from Ghana. I'm very privileged to moderate this very important discussion. And without much ado, I want us to delve straight into the questions that we have for our esteemed speakers. So we'll start with Mrs. Cole. We want to know, from your experience, what are the first steps for a general counsel to institutionalize mediation so that it becomes a strategic first response rather than a late stage afterthought?
Thank you very much, Sam. Well, good afternoon, everyone. It's a pleasure to be here. Thank you, CIAB, for inviting me. Now, what are the first steps for a general counsel to institutionalize mediation as a strategic first response? The first thing I'll say is you have to get mediation written into your dispute resolution framework. That's the first thing. And that's what we see as an institution. Sometimes we have counsel or institutions come to us and there's no dispute resolution framework. It wasn't intentional. So a dispute arises, you have to contact an institution and say, hey, I want to bring my case here. But there's no dispute resolution framework, there's no clause. So you also need to have all your contracts have multi-tier clauses that require negotiation, mediation, arbitration, as different steps. Sometimes now they do it simultaneously, but as different steps with different timelines, and you stick to those timelines. Fortunately, this is all covered under the Arbitration and Mediation Act. I'll give you an example why having a multi-tier clause is so important. That is a multi-tier clause that is clear and that kicks in immediately you have a dispute. Number one, look at a clause we got at the multi-door courthouse. It says the parties agree to enter into binding mediation or arbitration to resolve disputes. What do we pick when you come to us? Is it mediation? Is it arbitration? There's an alternative. In a properly drafted multi-tier clause, it's clear what comes first. Negotiation, 60 days, mediation, 30 days, and so on and so forth. You can even define, who is going to handle your dispute, the institution that will handle your dispute, and so on and so forth. The third thing, in addition to having, this in your clause, is that you should have an internal mediation protocol. When should mediation be triggered? At the point of a full-blown dispute, or when you see already that things are going sour? And who has the authority to approve settlement ranges? Within the multi-door, we find out that we have corporations get to the table. And sometimes when you sit at the table, say, give us a letter of authority. Beyond the letter of authority, can you crunch the numbers? Can you take decisions? So that's something that is an internal mediation protocol that should be dealt with, ahead of time. For internal capacity, please build capacity. Mediation is just not a walk in the park, not at all. It is such a strong dispute resolution mechanism. And now you have mediation advocacy training, which I implore all in-house or anyone who's going to represent clients to take. There's so many institutions that run mediation advocacy trainings. Do the training. And number 5, understand the referral process. We still get calls that say, how do we refer our cases to you or to whatever ADR center? There's so many ADR centers, So understand the process, understand how you can refer the case. And lastly, track your mediation outcomes ultimately, so that your board will understand that you are meeting with compliance metrics and governance metrics, and statistics show that mediation works. So just don't do mediation, begin to track it. Yes, Samuel, those are just a couple of things that I believe in-house counsel should do immediately, and which will structure their approach to mediation and their approach to dispute resolution once it happens.
Thank you very much. I think from that we can move to Mr. Kisonya. Flowing from what Mrs. Cole has said, what governance or board level mindset shifts needs to change in order for us to, incorporate mediation as part of our corporate dispute strategy?
Thank you very much, Samuel. One of the greater misunderstandings of mediation is that it reflects that your case is weak. If you decide to do mediation, it means you know you don't have a case, so you're trying to get out of it. But one of the things that needs to change is people need to understand what mediation is. Mediation is not about appeasement, it's not about going to beg the other side. It's not just about bargaining. It's not just about trying to, bargain your way out. And it's also not about just simply negotiating a solution. Mediation is a process that allows parties, because you have a trained mediator who is able to bring out the real underlying issues, which most times the purely legal technicalities are not able to bring out. So we need to let the members of the board, members of the of administration know that it's not about compromising your position. It is not about being a weak matter. It's actually a very, very effective way of addressing mediation, and it's an effective bottom line engineering tool because you save a lot of time, you save a lot of expense, and most times you also save a lot of public image because there's one aspect of mediation which must be emphasized. It seems mundane, but mediation is confidential. And when properly handled, you'll find that you are able to deal with things which you might be reluctant to bring out in a courtroom, which is a public place. But in mediation, of you have the benefit of um, confidentiality. Number one, you have the benefit of being able to address other issues for which there might have been difficulty to frame under strict legal technical law matters. So you can address what it really matters. Number three, mediation allows parties to frame solutions that can be extremely creative, and it gives parties an ability to arrive at solutions and agreements that suit both parties and enable them to move their business forward. And you find that, especially in terms of relationships, I remember very well. I mean, I spent many years of my career, almost 25 years, working in the law department of what we now call ExxonMobil. And one of the things that we we're concerned about is dealing with our host communities. And you'll find that I'm pleased to say that at least in the time in our own era, because I realize that a full 25 years have since passed since I retired. In our own era, mobile was commendable for having the least disruptions from its host communities. It was reputed for having the least number of cases in court against its host communities. And so it had smooth operations. What was the key to it? Whenever there was an issue, parties came to the table, discussed it, and found a solution that benefited both sides. That's the beauty of mediation. It saves costs, it saves money, it saves reputation, it preserves relationships, and by so doing, you can actually measure the effect on the bottom line. So, and that is the way we always sell it to the board. In fact, a major component of our policy was that you must always carry out what we call a cost benefit analysis of every matter you had before you went into it. You may find that if you've been sued for 1 million, why spend 5 million to defend it? You lose money. Mediation gives you an opportunity to save that money, and it allows the least disruption to operations than any other process.
Thank you.
So
Thank you very much.
that's the sell point.
Thank you very much,
And that
Mr.
always
Kisime.
was the sell point and still is. You're welcome, Sam.
Yes, I think one key point you mentioned had to do with the fact that mediation does not signal weakness, and it's important that we note that. Mr. Omaka, can you assist us to understand the best timing to, start this mediation process so that we do not show or we don't show signs of, weakness in terms of our strategy in dispute resolution?
Good afternoon, distinguished colleagues. Good afternoon, Sam, and everyone. It's a pleasure to be here. Sam, I hope the sun is not shining too much in Accra the way it is here.
It is actually. We have a very hot sunshine currently after a heavy rain last night.
Yeah, thank you. So before I actually pick on my question, let me comment on a point. I think an overarching important point that Ms. Kuhl mentioned in her intervention when she talked about the need for precision and clarity in a mediation clause, in a multi-tiered dispute resolution clause, right? I think for in-house counsel, that is an imperative. It's extremely important that you draft your multi-tiered dispute resolution clauses with such preciseness as to leave no room for ambiguity. I'm involved in a dispute where the dispute resolution clause says that if the parties do not resolve the dispute by mediation within 90 days, then they can proceed to arbitration. Then the question then is, what is resolving the dispute within 90 days with mediation? Is it where the parties fail to reach an agreement? Or is it where the mediation does not complete? So such very fine line issues, it's very, very important that in-house counsel are very conscious of it, they are aware of it, and they leave no room whatsoever for ambiguity. Now, coming to the question you have asked me about timing. Now, like Mr. Akesanya said, mediation is not a plea for mercy. It's not a plea for weakness, right? It's an important tool in the toolkit of a dispute resolution resolver to apply in resolving a dispute. And in terms of timing, I think the most important thing is really the procedural pause. For instance, when you have a case management conference or a preliminary meeting, that is an important milestone in the course of an arbitration where you perhaps want to consider mediation as a means of resolving the dispute. And why do you do that at that point? Because at the point of the preliminary meeting, parties are still exploring the case. They've not seen the pleadings. And so it's perhaps a good time to bounce off the idea of mediation. I guess another time consideration is post-discovery advantage, all right? And this, I will say, is happens where perhaps parties have to do disclosure during the course of an arbitration. And then when pleadings are completed, all the documentary disclosures have been made, there is sort of reality testing. What happens is that parties see, at least they get a wide spectrum of the dispute, of what a party's case is. And then a party has to reality test at that time to say, do I want to proceed with arbitration?
Understand? I think he's having challenges with his network. Okay, so let's proceed. Let's proceed on that tangent. Same about timing. Again, Mrs. Cole, if you can jump in quickly to, address the issue of timing, especially with your institutional experience.
You talked about the best time, right, to bring in,
Yes.
to refer a matter.
Yes.
Yeah. So really, the best time, it would depend on each case. Some cases, yes, way ahead once you realize that issues have started arising, have a preventive measure within the institution that doesn't only take advantage of negotiation between the parties, but also bring in a third party. But we realize that some cases, you may not get anybody to the table until you go to litigation, or even until arbitration kicks in. We see that a lot. So that's why you have in some jurisdictions where you file a matter and then the matter is tracked straight to ADR because some parties just won't submit. Mr. Akisanya mentioned it. Some people think it's weak. It's weak of you to suggest mediation. So the courts help. So in responding to best time, it's case dependent. Always better, I say, as a preventive measure. But if for any reason the other party is not coming to the table, or for any reason you feel you look weak, even if, like Mr. Akisanya said, you won't look weak, use other measures such as filing the case in court. I'm sure you've been wondering why I'm saying so, but it happens. You can file a case in court and it makes them kick in. Or the arbitral clause, go through the mediation bit, they don't come to the table, get to arbitration. Within the arbitration, you know, as an arbitrator, we always say the door is open, you can always settle, then take that route at that point. So interventions happen at different phases of the case, you know, and of course, like we always say, not all cases are suited for mediation. If somebody's about to tear down your house or do something really crazy, that's not the time to be mediating. You should run to court. So they're very, 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 very varied opportunity to make that intervention. Yeah.
Thank you very much. Mr. Moka, before you dropped off, I don't know if you want to say something in just a few lines so we can move on.
Yeah, sorry for that internet downtime. So I was talking about the timing point, and I think an important stage where you can introduce mediation is where we're talking about bifurcation of the proceedings, right? Where there's going to be a separation between liability and quantum. It's important at that point for parties to consider whether they want to apply or introduce mediation as part of an ABMED solution or a med-app solution, all right? So for me, those are important periods. Those are important timelines and periods within an arbitration where parties can potentially introduce mediation. But of course, mediation is inherently flexible. The arbitral process is rigid, but I mean, with parties' consent, parties can modify the procedural timetable. So there is no fixed rule about that. And I'm sure it can be introduced at any stage in the proceedings, depending on what the parties agree.
Thank you. Thank you very much. Dr. Sonia, what typically prevents legal teams from, using mediation as a strategy? I think you mentioned something about mediation being postured as a sign of weakness, but I'm sure there are other factors that also, affect the strategy when it comes to using mediation as another tool for dispute resolution.
Yes, indeed. One great myth, and I do use the word myth deliberately, is that mediation is not binding. And I've had several lawyers and several persons who've been told mediation is not binding. But that is not true. Now, mediation is voluntary in the sense that nobody can force you to mediate. You cannot be compelled to mediate. You cannot be forced to sit or remain at the table. Yes, to that extent, it's voluntary. However, especially because I know I'm speaking to a very large number of lawyers, if not all lawyers, if I have signed an agreement, a binding agreement with offer, acceptance, and consideration, and I've agreed that I will sit at mediation, and one of the things that provides a loophole is the way the mediation clauses are drafted in the agreement, and that can be corrected. I'll come to that later. But the things that people think is not binding, but understand this: once you are at the table, once you come to a resolution, once both of you agree or all of you agree and have signed that mediation settlement agreement, and the mediator has also signed it, and all the people that have signed it, please don't be left in any doubt. It is as binding and effective as any other agreement. And especially if you go into court through multi-door courthouses, LMDC is is a major example, but there are one or two other processes that practicing lawyers know you may use. The only thing I'll say is that the LMDC process gives you a convenient way out of going into all the rigmarole. But once you get to that point where you have signed, you are bound. And I think that is one myth that needs to be dispelled from the minds of both clients as well as their lawyers. Mediation is only voluntary in the sense of up to the point when you get to the table. But once you've sat at that table, it's still voluntary. You can always walk away from the mediation at any point. But please note, once you have signed that agreement, and the other party has also signed, the mediator has signed, and in fact, if you've now gone further, and the ADR judge has signed it, and it has become valid and effective as a consent judgment of the Lagos High Court in the case of LMDC, for example, please, it is binding and it can be executed like any other judgment. So, in that respect, people should know that mediation is not as weak as it is. And so that's one major myth that needs to be brought to people's minds. And then also one of the things that one of the weaknesses that come out, and I think either Mrs. Cole or Mr. Mokwa have mentioned it, sometimes in the mediation clauses that are drafted, what makes it is there are no defined triggers or timings for the mediation. And so it gives the impression to parties that, well, they may take mediation into consideration. But you can correct that by the way the agreement is drafted. You can define clear timelines. When the dispute occurs, when a notice of dispute is given, the time frame within which to appoint a mediator, how many mediators, 1, 2, or 3, from where, who does what is to be done. You can even provide a maximum number of days for the mediation, with what the outline should be. So those are some of the things that we need to educate our people about. One other thing, I'm sorry, and let me just quickly mention this. Because I think Mrs. Cole referred to it in her call. People come to the table sometimes, and they are mediating, and then they say, "Well, excuse me, please, I need to call my managing director because I can't take this decision. Please, I need to call my director." I always tell people that is an act of weakness. In fact, you may think you are strengthening yourself, but if you are dealing with a mediator or a negotiator on the other side who knows all the things, it's a weakness. When you come to the table, you should come to the table knowing exactly what is your limit of authority, what you can give, what you cannot give, how far you can go, how far you cannot go. You don't have to declare it. That strength is what I like to encourage management teams to do, because it saves time, it saves money, it makes the mediation more effective. It stops all the back and forth.
Thank you very much. Ms. Cole, this leads us to risk. The question is, what role can institutions like LMDC play in de-risking mediation for corporations and also for regulators?
Samuel, please can you say that again?
I was talking about risk. I was asking that what role can institutions like LMDC play in de-risking mediation? Mr. Kisonya spoke about a lot of issues that come up in the mediation process up to the point of execution. So how can parties de-risk the whole process to make sure that some of these risks are mitigated to the minimum?
Awesome, thanks, Samuel. I'm happy. I was so happy when I heard Mr. Kisonya talk about what Mobile used to do, because that's just the kind of institution we'd like to work with, that thinks through, ahead of time, what it'd like to see when a dispute arises, because typically institutions, they have some major fears, and they don't even express these fears. The fears include issues around capacity. So they think it's a risk. Why should I bring my case to you? Am I sure you can handle it? So that's a capacity issue. Also, they're afraid of bias. We're amazed at how many people think, what's the assurance that there isn't going to be bias? And that stems from really lack of understanding about the mediation process, talking about mediation, even arbitration, but even more so mediation in terms of bias. And then unpredictability, they're not sure how the process works. How is it going to end? What's going to happen? Who's going to control it? And I want to begin to address this issue, and of course, reputational exposure. Now, when we deal with bias and capacity issues, what the institutions do is to make it clear that they have capacity. And how do you do that? Number one, let me use the multi-door courthouse, Lagos, as an example. And there are multi-door courthouses across Nigeria and across the world, really. Once you have neutrals are mediators, arbitrators, they're professionals that cut across a broad range. I'll speak for Lagos Multi-Door Courthouse, a broad range of people who are, like Mr. Kisonya is in the energy sector, lawyers or bankers or engineers, so on and so forth. That speaks to capacity. And what institutions do is that when we have a case, we match the neutral to the case. And that is a world away from where you're not sure that the neutral has capacity. Sometimes institutions also ask us for a list. They might even want to go ad hoc, but they write to institutions like the multi-door and say, look, we're not going to take a risk. Give us a list of your neutrals in the energy sector or in telecommunications, so on and so forth, in insurance. And we give a list. And then they go on to appoint somebody suitable to their case. So that's to deal with capacity. At multi-door, for instance, we have over 300 neutrals, and that tells you that's a broad range. And these neutrals are not staff. They're people sitting in their offices who are professionals. Then also, in terms of capacity, it's not just the neutrals who handle the cases. I'm particular about capacity for in-house counsel. In-house counsel in the institution. So like in the multi-door courthouse, the case managers are lawyers. So we're very particular about human resource. Who are the people handling your cases? One thing is the actual mediation. The next thing is the processing of the case. That's a whole ball game on its own, and that's case management. So that deals with capacity. Once you can deal with this, you have more people who will come to you as an institution and say, hey, I want you to handle my case because I'm sure you have the right capacity. Capacity is way beyond people, and there's so many other things, structure and so on and so forth. You need to show that. Another thing institutions do is that they provide an institutional cover and legitimacy. So it has a law governing it. Lagos Multi-Door Courthouse law, for instance, it has practice directions. You have the High Court of Lagos Civil Procedure rules because it's a court annexed mediation center. So you have all these rules governing you. And once you say you're bringing your case to such an institution, you're bound by these rules. And that's a lot of benefit because it provides legitimacy. For instance, in the High Court of Lagos now, if you have a matter that comes in, the court rules say that your case, if it is a commercial dispute, will automatically be tracked to mediation or to arbitration, depending on what your contract says, or if the case fits, ADR. So that's what institutions do. They provide institutional cover and, legitimacy. In addition, I think Mr. Kisonya mentioned this also. Institutions have structured procedures, timelines. For instance, you have a timeline of 30 days at multi-door from the date of first mediation to conclusion. I think we just started this about last year. 30 days from date of first mediation to conclusion. That's institutional. It has confidentiality frameworks. You must sign an agreement before you commence. Mediation agreement, confidentiality agreement. We have ethical codes. We have a whole handbook for mediators and arbitrators on ethics. And you can't breach the ethics. If you do breach the ethics, the parties write a petition. So it's so structured. And that's what removes the risk that you feel you might encounter if you go to mediation. That's the benefit of using an institution. You also have process custodians. So it's not just about process, it's not just about giving you a venue. It's also a process that needs to be followed. And you need that process to be sure of the benefit of using an institution. And then something people worry about is neutrality. Let me address this issue of neutrality. The hallmark of a mediator, a couple of things. There are many principles. One of them is neutrality. Another is confidentiality. But let's address neutrality because it affects perception. So what institutions do is that they make sure that they act as a neutral convener. The institution itself is a neutral convener, not taking sides with anyone. Then the neutral themselves are trained to maintain neutrality. So we have a transparent mediator appointment process. We have mediators and we have a transparent mediator appointment process. You can ask for it if you want to, And then also, another thing that worries companies and they think is a risk is, Mr. Kisonya mentioned this one too, is reducing enforcement and legal uncertainty. You think that the settlement terms at the end of the day are not enforceable. They are. They are binding, even as a contract, before you go to the court. The benefit of a multi-door system or quarter-next mediation center is that that agreement passes through an endorsement and enforcement process and can be enforced and will become enforced as a consent judgment. Even if it doesn't go through that process, it is enforceable as a contract in itself. So, when you look at all of these things, really, at the end of the day, what's the risk? What's the risk to the company? There really is no risk because of the structures, really detailed structures that have been put in place. In addition, in some multi-door courthouses like Lagos, Lagos started it out, we have direct intervention. So even if you feel your case is weak, and we've had cases like that, and somebody makes a call and says, you know what, I don't want to be the first person to approach. We have a door called direct intervention. We will do the approaching for you. That's institutional based. So it just cuts through, all these layers of risk and so on and so forth, and just helps people use the center in a way that is fruitful for them ultimately and beneficial. As I think institutional mediation is a great way to go. It just cuts through a lot of headache for you. Not to say ad hoc doesn't work. Some need ad hoc, but you just need to know the benefits of which so that you choose appropriately. Yeah. Thank you, Dan.
All right. Thank you. Thank you very much. Yes. At this point, I want to remind participants that you're allowed to ask questions. If you have questions, please put them in the chat box. You don't need to unmute your mic. Just put them in the chat box. After the deliberation with the esteemed speakers, we would read your questions out and then they would have an opportunity to answer them. Mr. Mwakwa, in the context of arbitration, right, how can we use mediation in a way that it works best for the parties? Is it before arbitration, during proceedings, or maybe for certain key milestones?
Thank you, Sam. I'll answer that question in a minute, but let me briefly comment on the point Mr. Akinsanya made about the myth of mediation not being binding. And again, I think Ms. Cole actually touched on it. Recently, I had a conversation with one of our very senior ADI practitioners in the country. And he said to me clearly that, Godwin, I don't believe in mediation because it is not binding and there's really nothing that anyone can do about it. And to say that my heart was broken because here's a gentleman who has been a doyen of ADI in this country for about 40-something years, right? And that is his reality. He is saying mediation is not binding. And I'm sure if he has to address an audience, he will say mediation is not binding. Mr. Akinsanya described this as a myth. I don't see it as a myth. I see it as the reality of some people, some practitioners, right? But then why do people think it is not binding? Let me break it down. There are two mediation agreements involved in any mediation. The first is the mediation agreement itself, by which parties refer their disputes to mediation. That is a binding and enforceable contract by which parties agree to go and resolve their dispute mediation. Then at the conclusion of the mediation, there's what is called the Mediation Settlement Agreement, or MSA, which is the outcome of the mediation process and which is enforceable. So those are the two agreements. Now, you hear Mr. Kinsoyan say that, well, it's not voluntarily. I mean, it's voluntary, but you can walk out before you sign the MSA.
Yeah.
That is the general viewpoint, right? But I want to make a controversial statement. I disagree. And I believe that mediation is a binding process all through from when you sign the mediation agreement to when you conclude the MSA. And why do I say that? It's simple. It is a contract. If you sign a contract to go to mediation, then you must see the mediation process through as a good faith effort. And say, well, you see, it's a voluntary process. I'm going to opt out. I don't share that view. So for me, mediation is a binding process all through. You don't have an option to opt out. If you opt out, then you are breaching your contract to refer your dispute to mediation. And so for me, I think I needed to express that point to reinforce the bindingness and the binding nature of mediation all through, to say that once you are in, you are in. It has no weakness. That's my personal view. Now, to your question as to when is the best time, whether before arbitration, during proceedings, or after key procedural milestones. Again, I believe, given the flexibility of the process, it is for the parties to agree. But I will suggest that mediation often works best when parties have closed their pleadings, right? Statement of claim, statement of defense have been filed, the wall lines have been drawn, parties know what case they're going to meet at the mediation. Those have been clearly defined. And before the parties incur the massive cost of proceeding into hearing, because hearings can be very expensive. You have to call witness, perhaps there may be expert witness, you have to rent halls, you have to pay lawyers and all of that. So at the point when parties have closed their pleadings, I always think that it's a better time to have what I call a pause, a post-memorial pause, review the situation and say to yourself, do parties at this point want to introduce mediation to resolve their dispute? And the time is perhaps where an injunction has been issued by an arbitral tribunal. It's not impossible that at that point, a party may look at it as a prime window because the status quo is going to be maintained. And if a party is going to be affected by that status quo, mediation to try and resolve the parties' dispute. The another point I will say is where post-disclosure, if the parties have to go to disclosure, get to the point where they have to disclose, make documentary disclosure, that's a very good time again to introduce mediation dispute, because when evidence comes out and parties see that, look, the evidence is so compelling, it's so cogent, you can't rebut it, then perhaps somebody will have to reality test and say to himself, well, you know what, at this point, I don't think it's worth it, and to be honest, I have been in that position as well, where, in a matter that I was involved in, the party had to have recourse to mediation following the documentary disclosure in that case. So for me, those are key timelines, but I keep emphasizing there's a lot of flexibility in the process, and these timelines are not locked, stock, and barrel. They are very flexible, and parties can introduce mediation when they see fit and when it's convenient for them.
Thank you. One key theme that runs through has to do with the mediation clause itself, the dispute resolution clause itself. And I think that's one key point we need to highlight here, and Mr. Kisonya can help us with that, in terms of the common drafting mistakes we see in dispute resolution clauses, especially the multi-tier ones.
Okay, first of all, let me thank Mr. Godwin Amoaka for reinforcing my conviction that mediation is binding. Thank you very much for that. Coming from a senior advocate of Nigeria, I think that is a worthy endorsement. Mediation is binding. Thank you very much, sir. So at least going away from here, we can go away from that myth. So what are some of the drafting clauses? We've heard that we should try and have multi-tier clauses in our agreements, but sometimes there might be little things that might make that weak. And I'd like to quickly I might want to quickly highlight a few. One that I've seen, and I'm speaking from experience now, because I've been in-house, I've been outside the house and trying to, practice law and lately mediation. Number one fault is that mediation is often in drafting. People say mediation, parties may attempt mediation. Parties may. I think that makes the step voluntary and makes it unenforceable. A party who is acting very tactically can bypass mediation entirely and proceed straight to arbitration or litigation because there is no mandatory precondition. I believe that in best practice, and I've always insisted on this, you should say the parties shall first attempt to resolve the dispute by mediation. Clear, unequivocal. Shall. The second weakness is that they don't have any defined trigger or timing for mediation. Mediation is mentioned, but no time frame is specified. So a party can stall indefinitely, claiming that mediation is still under consideration or argue that it never formally commenced. So I again would recommend that in this case, define your clear timelines. When the notice of dispute will come, the time frame within which to appoint the mediator, the mediation window, 30 to 45 days. I'm very grateful for various dispute resolution centers such as the LMDC that are now, and nowadays we even have mediation even at the Court of Appeal, and I understand that they're working towards even doing it at the Supreme Court now. But the important thing is that they're telling us when you start from start to finish, it will be 30 days. I think parties themselves should follow that example in their mediation clauses, and they should have a clear timeline. And then one mistake that comes up a lot these days, everybody says ADR, ADR, ADR. Now, actually, ADR includes arbitration of technically. So when you say ADR without distinguishing it from mediation, there's always sometimes a tendency to automatically default into arbitration. So it's better to expressly and separately identify mediation. If you want to do consultation, or maybe top executives will meet and try to negotiate a settlement, make it clear. Then they shall go to mediation. Then they shall do this. And then the other thing is that is a lesson I think we need to learn from the arbitrators. There is no mechanism in most of these clauses these days for appointing the mediator. The clause requires mediation, but it gives no appointment mechanism. So a recalcitrant party can frustrate the process by refusing to agree on a mediator. So best practice, I think, should be parties should put in there, how will we appoint our mediator? And if we are not able to come to agreement, then LMDC, LASIAC, ICC, CIAB. I understand this is that CIAB is is getting more into mediation and that kind of thing, etc., etc. You can put in an appointment mechanism, and then you should also make sure that parties are committed in good faith. They're obliged in good faith, so that it prevents any party perfunctorily from refusing to engage, and you will have no basis of suing him. We must require good faith participation in the mediation. And one thing that Mr. Mwaka pointed out, which I think is important, is there should be some kind of consequence. Okay, fine, we can say it's voluntary. Yes, agreed. But there must be a consequence for just acting carelessly. You should not just simply be able to walk away. Even at the ADR level, I was in a matter in which parties said, well, we're not interested again. And I said to them, this is a court-referred mediation. You were ordered here. You need to go back to the court that ordered you here and tell the court that you're not doing it again. I cannot, as a mediator, release you because the court ordered you here. You need to go back to who ordered you. And the last one I'd like to just quickly mention, there's several others, but these are the ones I'm referring to as the major ones. There's one that I saw recently that really troubled me. And once I was told that I would be on this panel and I saw the question, I said, I must mention it. Please do not ask that mediation will be conducted without prejudice to arbitration. Okay, do not say it will be conducted without prejudice to arbitration, because what happens is that you are actually making mediation as a courtesy step, not as a gatekeeper. And therefore, parties will just say that, oh, mediation is just a box ticking exercise and they can do what they want to do, go on and do what they want to do. We'll just quickly do it. We are seeing it happen now, even with the procedure under the Lagos State High Court rules, where parties talk of this bundle and so on and so forth. And parties write later, we have tried, we have gone to mediation, we have done this. You know, that we need to draft it as a true condition precedent and not a symbolic prelude. We need to draft it as a true condition precedent and not merely a symbolic prelude. And lastly, we do it in ordinary law. We do it with arbitration. Why not with mediation? What am I talking about? Governing law, language, and certain aspects of processes. One thing that I've shared with a lot of my colleagues is that when the Court of Appeal started the Court of Appeal mediation practice, and a few of us had the privilege of being invited to common as co-mediators there, something occurred to me that it was new to me, but I find it useful. There's nothing that says you should use only a single mediator. Nothing prevents you from having two mediators. Nothing prevents you from having three mediators. Sometimes the complexity of the matter may require you having more than one mediator, having two mediators, whatever it is. It all depends. So we need to look at seats. Where are we having the mediation? Where will the mediation take place? What is the governing law? We should not be silent about that. And also, if possible, we should establish at least some minimum procedural rules, or have something that you refer to. You can do it under the rules of the Lagos Multi-Law Court House, under the rules of LASIAC, under the rules of ICC, under the rules of CIAB. I don't know whether you have it, whatever it is. Let there be some procedural rules put in place that can govern parties. So we stop treating mediation as an informal, let's do it. Let's not do it. It's a nice to take step before we go to the real thing, Joe. You know, like we say in this part of the world, the real thing is arbitration, or the real thing is litigation. You know, let's quickly get through this. But we can now begin to adopt mediation rules, adopt seat, adopt governing law, and so on and so forth. And
thank you very
that
much.
is also important. I'm sorry, just one last point on that. It's very important because these days you also have the Singapore Convention, which also creates rules that makes your mediation settlement agreement enforceable across border or otherwise, and you need to be able to put that in.
Thank you, Mr. Akisonya. That's very insightful. That's a very good perspective. At this point, I also want to remind participants that we have set up some polls, some questions for you to answer. We hope that you would answer them. At the end of the discussion, we would go through the polls. You will see how you guys answered the questions, and then we would give the floor to our speakers to, comment on those questions. Mrs. Cole, can you help us, now that we are moving towards enforcement in terms of consent awards, what safeguards are in place to ensure that these consent awards, or MSAs, as Mr. Mwaka refers to them, remain confidential and are not used as a fishing expedition for arbitration?
Okay, thank you, Samuel. And thanks to Mr. Akisonya for mentioning something very germane to my heart, which is, what happens when parties refuse to mediate, then go back to the court. I must say that I'm really pleased at what the Lagos State Judiciary is doing now. Some judges will send you right back. It's court-mandated mediation. So to just say, go back to the multi-door and go through the process And also the multi-door actually sends to the court a status report. But the status report does not talk about the nitty-gritty of the case, but it will talk about attitude. And it informs the process, that the court will take. That's really a deviation from the way things have been in the past. Now, to your point, Samuel, and to your question, what safeguards are in place to ensure that consent awards or mediated agreements remain confidential and are not used as a fishing expedition? This is simply really speaking to confidentiality and process integrity. First of all, mediation and arbitration are treated as distinct and compartmentalized processes. They're not the same process. They're completely two different processes. And it's so important to say this because it will amaze you to know that we still have people who walk into the center and say they came to us for arbitration. But what they mean is mediation till today. So it's so important to say that they are completely different processes. Mediation is a process where a neutral third party enables parties get to a settlement, the mediator facilitates a settlement, and the settlement agreement is owned by the parties. The parties decide the settlement. But arbitration is like the court process. It's just that it's done in an informal environment, if I can put it that way. At the end of the day, you get an award, which is like a judgment. So they are completely different processes. And we should not at any time mix those two processes, In addition, fortunately, the Arbitration and Mediation Act has now said, unless parties otherwise agree, a mediator shall not act as an arbitrator in respect of a dispute that was or is the subject of mediation proceedings. Now, this wasn't clear before under the Arbitration and Conciliation Act. This has been made very clear now, unless the parties agree. And I think it's such a good thing. Even before now, the institution already was separating it. Typically, the mediator, if an arbitrator has commenced proceedings or hearings have begun, typically an arbitrator will say at any point in time, you can go into mediation, you can settle out of out of the arbitral tribunal and all of that. And what we do is that the arbitrator steps aside and then we appoint a mediator separately. Then the terms of settlement that the parties reach then become a consent award. It's given back to the arbitrator and then becomes a consent award. So that's the process that is employed. And that ensures that there's no mix up in information. The mediator does not share notes. Please, let's note this. You will see that when mediation commences, you hear the mediator say something like, I will take notes, but these notes I'm going to take, I would not use them. I'm only taking these notes to remember just a few points. The mediator doesn't share notes, impressions, or admissions with the arbitral tribunal. So that preserves confidentiality of the negotiations, the substance of negotiations that have taken place do not get to the arbitrator at all. And then also, Section 76 of AMA, the Arbitration and Mediation Act, also says information relating to the mediation proceeding shall not be ordered by an arbitral tribunal. It's protected by confidentiality under the law. Can you still hear me, Samuel? Am I frozen?
I can hear you.
Yeah,
no,
we can hear you clearly.
Okay, now, that's in dealing with the separation of mediation and arbitration as provided by the law. In addition, there's the principle of confidentiality. I talked about key principles that govern the ADR process, both the mediator and the arbitrator. One of them is confidentiality. At the institutional level and even ad hoc mediation, they sign a confidentiality agreement. This is procedural. You sign a confidentiality agreement which says that statements made during mediation are without prejudice. So you can't disclose. Documents prepared solely for mediation are inadmissible in subsequent proceedings, and settlement discussions cannot be relied upon as admissions of liability. Now, we find that counsel sometimes writes to us and asks for record of proceedings. And we say, we don't have any record of proceedings. We don't write anything. The mediators don't write anything. We have no record of proceedings. It's important to understand these things. It's completely confidential. So when you see a mediator take parties into a room and come out, they don't disclose information except the parties ask them to. And overall, all that is discussed is not, documented in the settlement terms, except the settlement agreement, not the conversations. So that privileged information does not get into the settlement terms, except the
Okay.
parties want it to.
Okay.
Another thing is that we have carefully drafted settlement agreements. So I'll tell you about a case we had a couple of years back. It came from the court.
Briefly in 60 seconds, please.
Okay, but the court itself, by the time we did the settlement terms, the parties said, you know what, the settlement terms, I don't want everything to go back to the court. I only want key issues to go back to the court. And it was bifurcated. We kept some of the settlement terms apart, and they wanted. So, in all of this, you see that the institution and the process, through documentation and various safeguards and ethics, ensures that information is not crossed from mediation to arbitration, or even from mediation or outside arbitration. There's so many safeguards, that have been put in place. Thank you,
Thank
Samuel.
you. Thank you, Mrs. Cole. Yes, Mr. Moka, same about consent awards in terms of enforcement. I think you mentioned mediation settlement agreements. The question is how we can use these consent awards and these mediation settlement agreements to have the same effect as if we had gone through an arbitration process or litigation.
Okay, thank you, Samuel. That in the
Hello. Hello. I think there's a break in his network. Mr. Akisonya, if you can help us take that question.
Can you kindly repeat it?
We're talking about the effect of consent awards and mediation settlement agreements, how we can have these, awards or settlement agreements have the same effect as in terms of arbitration or litigation.
Wait, put very simply, thank you. Put very simply, once you have signed your mediation settlement agreement and it goes back to court, it is adopted and entered into judgment as a consent judgment of the court. So it is as effective as an award that has been enrolled in court as well. So it is exactly the same effect, no difference. Now, the only area where one can do a little bit of extension is there are certain awards, there's certain mediation settlement agreements because of their content, because of their subject, that may be a little limited in terms of entering them outside jurisdiction, enrolling them in another jurisdiction. And you need to look at the provisions of the Singapore Convention. I don't want to go into that today. That I think will be going over syllabus, like we used to say in school.
Yes.
But short answer, a mediation settlement agreement which has been signed into effect as a consent judgment of the court by an ADR judge or any other judge has the same strength and power of execution as an arbitration award in the courts. No difference. They are the same strength. No difference.
Okay. Thank you very much.
Thank you, Sam.
Yes.
For the internet downtime. Now, an MSA can be enforced as a content award. That is an award that the parties have agreed on. If it was an MSA that resulted in the course of a mediation. So what typically would happen would be that at the end of the mediation process, the parties reach an agreement, and then they go back to the arbitral tribunal and get the arbitral tribunal to enter the settlement agreement as its award.
As its award.
Its award. Yeah. And Section 82, sub 2 of the AMA clearly provides for that. All right. It's one of the three methods of enforcement recognized by Section 82.2 of the AMA. The first is enforcement as a contract, and the second is enforcement by court. But in the arbitral process, it can be enforced as a consent judgment. And two things typically will play out. Even if an international arbitration is seated in Nigeria, then it takes the benefit of the New York Convention as well, because it becomes an award, becomes an international arbitral award that can be enforced anywhere in the world, even though it's a settlement agreement. But if it's a domestic arbitration, then of course it's going to be enforced in accordance with the domestic rules of enforcement. All right. So that is the framework for enforcement of a consent award, of a consent for mediation settlement agreement within the context of a consent award, That is how it has been provided. But before I close it on this point, let me quickly say I was going to talk back about when I said mediation is binding. Now, if you watch it,
just before that, Mr. Waka, you can comment on that and give us your final words as we are bringing the discussion to a close as well.
Yeah. Yes. So just a quick. You see, in England, what has happened now is that as a precondition for litigation or arbitration, the courts would typically award costs against a party for unreasonable conduct to mediate. And that's the point we are making, that there is some bindiness. So if you act in bad faith, if you act unreasonably not to see the process through, then the English courts would award cost against you, even if you were the winner in the litigation at the end of the day. So that cost will be factored. The fact that you refuse to participate you unreasonably refuse to participate in the mediation process, right, will be taken into account by the court in awarding cost against you. I think it's something that we have to bring back into our own domestic environment and apply. Thank you.
Thank you very much. Final words, Mr. Akisonya.
Okay. I'll try to make this as brief as possible, and I'll try not to repeat anything we've said already. I'd just like to close by saying that parties should understand that mediation is an effective dispute resolution process. It is not inferior in any sense, not to litigation, it's not inferior to arbitration, it's not inferior to any other method. It's a very effective way of resolving. Secondly, I want to also mention that what is a let me say bye-bye to all my colleagues on the call here. Those of you who are in-house, mention was made earlier of an aspect of mediation called mediation advocacy. And I think if many persons, especially in-house counsel and other senior executives within companies, would take the opportunity to go and to qualify, to learn about mediation advocacy, it would enhance even the results they get from a mediation, because mediation advocates come in not being litigation hawks, to win a case, but they are able to assist the mediation process, which enables both sides, and at least their side, to get the best out of the mediation process. So that will be my closing call to everybody. Please learn mediation, number one. Number two, please, for those of us who are in-house, learn about mediation advocacy so that you'll learn the skills that enable you to give optimal support to your company and to the mediator in addressing the issues in dispute between your organization and any other organization or person. Thank you, Samuel. I want to say thank you to CIARB for allowing me to speak in your program. I am not an arbitrator, so I'm a visitor. I'm a guest. Thank you for honoring me. Thank you.
Thank you, Mr. Akisonya. Yes, Mrs. Cole, final word.
Yes, thanks, Samuel. Just to say quickly, in response to what Mr. Mwaka said about what happens in England, in Nigeria, we have Order 53 Rule 2, which provides that where an offer of settlement is made in the course of ADR, and counsel need to note this, if an offer of settlement is made in the course of ADR and you reject it, then you go to court and the judgment is not in excess of that offer, you will pay the costs from the time of the offer all the way up to judgment. So we have it in Order 53 Rule 2 of our own civil procedure rules in Lagos State. And then my final word is, please get trained. Please get trained. As a mediator, as an arbitrator, as a mediation advocate, you know why? You just understand the process better and you can give your client value when you're in this process. Thank you so much to CIAB for having me. And thank you, Samuel, for great moderation.
Thank you. Thank you very much to our esteemed speakers and our participants as well. I think this has been a very insightful discussion. We've had to see various perspectives from different stakeholders in the whole dispute resolution system. And I think they've done very well. We should give them a round of applause. Thank you very much. At this point, we have to move to our polls. But before that, we would encourage the participants to ask more questions. We need to understand that we need to get feedback from you in terms of your understanding of these topics. So we would appreciate a lot of questions from the participants. Now, having said that, let's see our poll results. Can you see my screen, all of you? Is the poll clear for all of us to see?
Well, I'm seeing the poll, but I'm not. Is that your screen?
No, it's the
that
poll.
Says mediation as a strategic tool.
Yes,
no.
Yes, that's
Okay.
exactly the poll. Yes,
Okay.
I think one question we should look at is probably question 2. What is your biggest challenge when suggesting mediation to the board? It seems that there's a bit spread out, in terms of the win-win. We've already talked about a bit of it, and the fear that the other side will not follow the agreement. I think that has also come up in this discussion. We've essentially trashed that myth, and then the belief that it will just delay the real resolution in arbitration. Okay, so let's hear from our speakers. Mr. Kishonya, you can start. What do you think about the viewpoint from our participants in terms of the challenge in suggesting mediation to the board?
First of all, I want to be careful that I understand what you're asking me to do. On my screen, all I see is question 2. What is your biggest challenge? I see single choice, and then I don't see anything else. I don't see the answers. I don't see.
Okay.
Am I doing something wrong?
No, you are not. You can't see the result.
Well, I can't see the result. Okay. I think I mentioned earlier that one of the biggest challenge when suggesting mediation to the board is the sense that you think our case is weak, and in some cases, some CEOs and some senior executives will just simply consider that you're not being diligent enough in advocating the rights of the organization. You're not as committed. You're not as loyal, and no, we need someone who is committed, somebody who is really patriotic, if I can use that word in terms of a company. So the biggest challenge is that the people on the board, most times the people on the board, they don't understand mediation. They don't understand the elements of it. They don't understand how it is done, who does it, where it is carried out. You would be surprised. Like I think it was Mrs. Cole who mentioned people will walk into the LMDC. They have come for mediation. They say they've come for arbitration. I sit down as a place and they say, learned arbitrator. And I said, no, I'm not an arbitrator here, and so on and so forth. So I think the biggest challenge is ignorance. And I think that is the challenge to all of us as practitioners, even to CIAB as an institution. We need to get people educated and enlightened as to what mediation is, its benefits, how it is done, how it is enforced, and how it helps them to save time, save money, save reputation, save relationships. Ignorance, that is the biggest challenge.
Okay. Let's move to another question for want of time. So question 8, do you feel more confident in mediation if you have an arbitration clause as backup? We have it evenly shared, 50%, 50%. One house says that yes, arbitration provides the leverage we need to settle. Another house says no, I think mediation should stand on its own. Mrs. What do you think? No, let's ask Mr. Mwaka rather. I think he has the experience there.
Yeah, thank you. Can you hear me? Thank you.
Yeah.
I agree that that arbitration is the hammer. It provides the leverage, while mediation is the handshake. All right. While there are two different toolkits in the toolbox of an ADR practitioner to use, right, in resolving a dispute, I see some interdependence, and that's why you have variants like ABMED, MedApp. You see Section 82 of the AMA recognizing the fact that the mediation settlement agreement can be enforced as an arbitral award. So the key point is this. If you are at arbitration and you have a recalcitrant contractual counterparty, by the time you outline your case in your pleadings, that perhaps will be the leverage you seek using the arbitral process. Or by the time you go through documentary disclosure, all the evidence, the party reviews the documentary evidence and says that, look, you know what? It's pointless pursuing this arbitration to its conclusion. I think I should rather settle. It will be reality testing at that point, all right? And that's when you introduce mediation. So I think, yes, arbitration should be the hammer, and then mediation should be the handshake in resolving the dispute at the end of the day.
Okay. All right.
Samuel, please, can I please allow me this indulgence? And I'm going to speak with trembling lips. 30 seconds, yes. There's a very little known procedure, very unfamiliar, but which is available to parties, which is called early neutral evaluation. And I think the more effective tool after you've done your pleadings and all of that my learned friend is referring to, and I'm talking to the learned SAN, is I think maybe that's again another area of ignorance. At the point where all the pleadings are in place, it may be helpful to get an early neutral evaluation, and that will help parties know where they are. It will help them decide, should they go with litigation, go with arbitration, or go with mediation. Let me shut up there. 30 seconds, I'm done. Thank you, Samuel, for the indulgence.
Thank you. There are questions in the chat. This is cool. So we would ask you one question that has come up just about now, and then Mr. Mawka will ask you the last question, and then we close for today. So Ms. Cole, thank you so much for drawing our attention to Order 53 of the Lagos High Court rules. Please, do you have any instance or precedents in which the court has properly applied the provisions to punish bad faith conduct in mediations?
Yes.
I think there was a case. It's been years, and I do not have a case to cite, but it's been years we saw it, and we've always wondered if it's being used. But I think the point is that the court does not suo motu go ahead to do that. We have asked this question severally, and it's said that counsel will need to raise the point and reference the rules, and then the court will kick in. And so that's the challenge we have. Not that the court will suo motu make that or give the order or give the judgment, or for terms. But I want to say something quickly. Mr. Mwaka, you said that the mediation is a handshake. Mr. Leonard Silk, I don't think it's a handshake. I think AMA has made mediation the hammer, because in the court now, if you have a mediation agreement and you go to the court, you can't go past the judge. You can't go anywhere. So I think it's become
those in favor say aye. Those in favor say aye. All those in favor say aye.
We are cutting short of time. So,
but I describe it as a handshake in the context of the typical mediation-friendly environment where parties are allowed to talk, relax,
Thank you very much. Just a minute.
And all of that.
Just a minute. There's one thing that we have to discuss in terms of MedApp and ABMED. I think that has been a question that has run through in our chat box. So, Mr. Mwakwa, if you can quickly just talk about MedApp, ABMED, and how it works within the context of dispute resolution.
Well, ABMED and MedApp are both variants of arbitration and mediation, right? Where you try to fuse both processes. And I guess that's why these days, increasingly, some school of thought are beginning to see arbitration and mediation as somewhat integrated at a particular point, right? And that's the point where perhaps parties have agreed either before their dispute arose in their substantive contracts to have multi-tier dispute resolution clauses, right? Or after the dispute has arisen, and in the course of the dispute, for instance, an arbitration, the parties can still say, you know what, okay, let's go to mediation. Let's go and mediate. And a sensible arbitrator, looking at the nature of the dispute, the relationship of the parties, and the circumstances, will at times recommend mediation to the parties while the arbitrator stays the proceedings, all right? So you can use ABMED, in other words, which means you begin with arbitration and then you conclude with mediation. Or you can use MedApp, which is you begin with mediation and then you conclude the process with arbitration. They all have little differences and advantages here and there, but the key point is infusing both is that you want to get the best of two worlds, right? You want to get two worlds. And for most in-house counsel and for most corporates, there's really no point. There's really no disadvantage in trying mediation, even in the heat of arbitration. And I say so, because what you do ultimately, if you're successful, it brings time and cost efficiencies, time savings, cost savings, and it's efficient at the end of the day. So that is why I think increasingly we're beginning to see these variants come into play, and people are using them as part of their ADR toolkit.
Thank you very much. Thank you very much to all our speakers. This has been very insightful, as I said. I think we've enjoyed ourselves in this discussion and we've learned a lot. And I'm happy about the debates that we are having, which also shows that there are different perspectives in terms of our understanding about the arbitration and the mediation process. But it's also good for us to, learn from other people so we can use to improve our own, in-house strategy in terms of dispute resolution. Thank you very much. At this point, I'll hand over to Mrs. Banjo.
And thank you, Samuel, for great moderation. Well done. Thank you.
Thank you, sir.
I echo Mr. Akisonya's sentiment, Samuel. Thank you.
Thank you.
Wow, it was very hot in here. I need extra ACs to douse all the tensions and all the learnings. Thank you so much. I want to thank Mr. Adeyemi Akisonya, Mrs. Ashere Cole, Mr. Godwin Omaka SAN. You agree with me that it was an excellent webinar. We promised to always educate in-house counsel on topical issues, and I think they have just achieved that for us. Thank you so much. I also join all the speakers to thank Samuel for this excellent moderation. I'm meant to do a recap of what we have learned. Where do I really start from? Where do I start from? I want to thank Ms. Ashere Cole for dousing all our attention on mediation, because you keep going to mediation and you see the other party trying to block it, trying to do everything to stop it. And every fear we have has been addressed by our distinguished panelists. So thank you very much. All the myths about mediation is enforceable. You can enforce it just like a judgment of the court. And Mr. Mwaka told us every part of mediation is enforceable right from the agreement. And even if you don't have any agreements, you can always walk in, like Mrs. Cole told us. And I totally agree with my preference is for institutional mediation anyway, to give me all the comfort and peace of mind, like Mrs. Cole told us. Yes, so thank you very much. I hope we have all learned. This webinar was organized by the Corporate and In-House Counsel Committee of the Chartered Institute of Arbitrators, Nigeria branch. Watch out for, it's monthly, watch out for our post on the next webinar, which will be on another topic, which will be very relevant to the in-house and corporate counsel committee. So at this moment, I would like to call on the chair of the Chartered Institute of Arbitrators Nigeria branch, Mrs. Olushola Adegbomire, to give us the closing remarks and end this webinar.
Good afternoon. Thank you very much. This has been a very, very interesting webinar. This is one of my favorite topics, mediation. And, I am one of those who always says, let's start with mediation. And so for me, this has been very instructive, very interesting. I want to thank the three speakers. I want to thank Mrs. Ashere Cole, our Oga at the top at the Lagos Multi-Door Courthouse for a long time. Thank you very much for bringing your practical experience with people who come for mediation. I want to thank Mr. Godwin Omwaka, SAN. Thank you very much. He has been chair of ICPC, and they too also do a lot. I think that's really what they do, mediation. So, and of course, Mr. Yemi Akisoya. And Mr. Yemi Akisoya, because he has been in-house counsel for many, many, many years. So he understands what it is that in-house counsel are looking for. Our number 2 in the corporate and in-house committee, I think she just stepped off. I was watching her online. It was from her I heard many years ago at something called the Pound Conference. I think it was organized by an international group in conjunction with the LMDC, where she said that then she was in-house in, I think, Sterling Bank. And she said that, look, many lawyers come to Sterling Bank and they go to other places looking for briefs, and expecting to make a lot of money. She said, our business is not dispute resolution. Our business is our business, whether we're bankers or oil or trading or whatever. Our business is not to resolve disputes. So we do not allocate one large chunk of money to lawyers who want briefs to go to court for us. She said, we prefer those who can help us resolve our disputes without going to court, thus saving us money, saving us time, and saving us relationships. I have never forgotten that. And that has been one of my drivers as well in this journey of mediation first, or what I call mediate first. I keep saying, hopefully, maybe the Corporate and In-house Counsel Committee will get there. I think they have it in some parts of the world. I think Hong Kong. They've got companies to sign up to something called a mediate first pledge, where very top companies have signed up to say, before we do anything, we will mediate first. We will try mediation. And I think it's working out. It's working out with the LMDC, ICPC, they're doing a lot. And so, I think it's something that we need to think about. The Corporate Counsel, ICSID itself has a mediation arm now. ICC, all the big international bodies are doing a lot of work in mediation. So it tells you that mediation is not just a poor cousin of arbitration or a poor cousin of litigation. No, it's standing on its own and standing strong. And with all of this, thank you. I want to thank all the panelists. I want to thank Samuel. You did a great job. I want to thank Ireti, and I want to thank Dr. Eso and Mrs. Justina Lewa and the whole team of CCIC. I thank you so much. You're doing a great job in the CIAP space and generally in the ADR space. So once again, I've taken too much time talking, but thank you very much. And we look forward to seeing everybody at the next webinar. God bless you.
Mr. Adedore, just to say Happy New Year, and it's ICMC, not ICPC.
I knew you would.
Before they come and arrest me. Before they come and arrest me.
Forgive me. ICMC. I was rushing. ICMC, not ICPC. Forgive me. Yes. Thanks.
Thank you, everyone. See you at the next webinar next month. Thank you.
Thank you, Reti. And for all the people who joined from Ghana, I saw a couple of people from Ghana. Akwaba. Bye-bye.
Bye.
Bye.
Bye. Thank you.
Bye.
I'm just enjoying some shito.